Okay, so let's go back to Mr. Gathwright's motion to suppress. Mr. Wise.
Hey, Your Honor, which would you like to
You pick.
address first? Okay.
You tell me.
Well, I have looks like the traffic stop first on the pile, or the, not really traffic stop. This is really multi-layered
Right.
motion, of course. But this is a motion to suppress all the evidence that comes following the traffic stop of Mr. Gathwright. And your first layer is that the stop itself was illegal. Obviously, everyone pretty much recognizes it's a pretextual stop. I recognize, of course, that pretextual stops are legal as long as there's an objectively reasonable basis for the stop. The problem here is that there was not. The two officers who conduct the stop testify that it's based on speed and tint. Now, they clearly have every intention to stop Mr. Gathwright's car. Detective Barry is actually in the criminal apprehension unit, which apparently his main job is to conduct stops like this. Despite all of that, neither one have a dash cam in their car. No one has a radar gun or any kind of way of clocking the speed. They both testify as to the speeding, that they estimate the speed, but they've only seen the car for a quarter of a mile, approximately. Neither one of them, even today, can testify as to what the speed was on the road where they conducted the stop. They said 35 to 45, but neither one of them even knows what the speed was. And just the same, neither one of them knows what they thought Mr. Gathwright was going at the time. So under the circumstances, Your Honor, particularly given that this was a plan all along to make the stop, this is not an objective, reasonable basis for the stop. And even though estimating speed can be a basis under Florida law, the Allen case that I discussed in the memorandum says the estimate has to be reasonable and credible. And in this case, under these circumstances, it's not a credible estimation of the stop. The second basis for the stop, the tint violation, is also not an objectively reasonable basis. And I have a couple of statutes I had not cited in the memorandum, but I can provide. If you'd like me first, I can cite them.
Sure.
But it's really just two traffic statutes that pertain to tint violations.
And for the record, you've handed me 316.2954 and 316.2951.
Yes, sir. And here, again, at least Officer Bear, I can't recall if Detective Griffin claims he sees a tint violation as well. I think he may have. But neither one of them end up measuring the car. Someone else does. They don't know what the reading was. But in any event, Detective Barry issues a citation for a tint violation at some point. But he issues it, as he testified, for the tint being less than 15%. The problem with that, Your Honor, looking at 316.2954, it states for most cars, I guess you could say, that is the law. If it's less than 15% in the visible range, that's a tint violation. And that's what apparently Detective Barry relied on. But it makes an exception for what are clearly SUVs, and the officers testified, and I think everyone knows a 4Runner is an SUV, but one of them testified to that fact, that something that qualifies as a multi-purpose passenger vehicle is allowed to have rear windows that have a light transmittance of at least 6%. So substantially lower threshold than the 15% that's most applicable. And then looking at the other statute, 316.2951, it defines what a multi-purpose passenger vehicle is. And I think that clearly is a sport utility vehicle.
Well, it says 10 persons or fewer.
Yes.
Does that include
The way I interpret it, Your Honor, it can be, it's 10 or fewer if it's constructed on either a truck chassis or has special features for occasional off-road operation. The statutes do not, as I see, define sport utility vehicle. I think that definition clearly would encompass a sport utility vehicle.
a 4Runner, a Toyota 4Runner can carry 10 people legally?
Well, 10 or fewer. I don't think that it has to be, if it were 10 or more, I think that'd be problematic, but it's 10 or fewer constructed on either a truck chassis or for special features for occasional off-road operation.
Okay.
So in any event, I think that encompasses what a 4Runner would be, and that pertains to when you read in conjunction with 316.2954, it allows for tint to be 6% or higher. So clearly, I think the officers, well, I quite frankly think it was a pretext. It was a case of stop the car and figure out a reason later. But in any event, it wasn't objectively reasonable because I believe they were relying on the wrong statute regarding the tint violation. Next layer, that would be the search of the car, of course. And I believe there really are two issues with regards to the search. Number one, Detective Griffin is the only one who allegedly smells the scent of marijuana. I don't believe that his testimony in that regard is credible at all, based on what you saw last week. So he stops the car. He's talking to Mr. Gathwright at the car window for quite some time. Detective Barry also comes to the car window to get the license. Detective Barry never smells marijuana. Detective Griffin, after some time talking with Mr. Gathwright, claims to have smelled the scent of marijuana. He says in his own words, it was a faint smell. Can't distinguish between whether it's fresh or burned, but he claims he smells marijuana. When the car is actually searched, there is a small amount of residue in a sealed mason jar. The quantity is too low to even be able to try to weigh it. There's no presumptive test performed on it, probably because it's of the small amount. It's in a sealed mason jar in a sealed backpack inside the car. There's no way that could be giving off any kind of odor of marijuana to be detectable from outside the car. And there's no indication, he testified he doesn't see any signs of impairment on Mr. Gathwright. Can't say that it's a smell of burned marijuana that might have taken place, if someone smokes in the car sometime earlier in the drives. He says it's a faint smell of marijuana. The facts just don't support his claim that he smells that from outside the car. But number two, even if he did, the law has changed considerably in the last several years. And the Williams case in particular that was issued back in the fall recognizes that there are numerous forms of marijuana or of the cannabis plant that are legal to possess under state law and federal law. Anything basically that qualifies as hemp under state or federal law looks like illegal marijuana, smells just like it, and no one can determine which it might be just based on the smell. Aside from that, of course, under state law, medical marijuana can be lawful in certain circumstances. And for a time, it appears this Delta 9 marijuana was lawful to possess. But in any event, the hemp is lawful under both federal and state law. And no one can really distinguish between the two. And that's why the Williams case has now held, similar to Baxter in the 5th district, I think the year before, that the odor alone is not enough to support stopping. Now, what happened in Williams, and I'm sure the state's going to argue that, is that in Williams, they found that even though that's the law now, when the search was conducted, we had a different precedent. So they said that the officers acting on good faith reliance could do that. Here, the problem, again, aside, just for the record, I would argue, saying that good faith reliance is okay really doesn't make a lot of sense in this situation because the laws that the DCA has recognized changed, happened long before this search was conducted. So I don't believe that it actually is reasonable to say officers should have been able to rely on prior precedent when the laws that legalize forms of marijuana were in existence. But the other problem in this particular situation is I don't believe officers were acting in good faith. We know very well they were looking for any reason to conduct a search of that car. I would suggest to you this is a classic case of we'll search first and we'll figure out justification later. I guess you could say luckily, but there was some little form of marijuana found in the car that they could rely on. But clearly, under the totality of the circumstances, this search is being conducted because they want to find evidence from this case and they're going to find a reason later. And they find a little bit of residue to justify it. It's not good faith reliance on prior case law. The next level, Your Honor, of this motion is assuming hypothetically that the smell of marijuana would give the reason to search the car. Law enforcement goes far beyond searching for potential marijuana and more importantly, in what they seize from the car. Law enforcement seizes these casings from the car. They're not unlawful to possess, just like the rifles. Now, there's a claim that handguns could not be possessed because of Mr. Gathwright's age, but there's no prohibition on possessing fired casings. There's no prohibition on, even if they're for a handgun. There's no prohibition on rifles. There's certainly nothing illegal about the laptop and iPads he possessed, but all of that is seized from the car based solely on this sense of marijuana. And we know very well why everything was seized, but there has to be an objective reason to do it, and there wasn't, especially for fired casings. I mean, he's not a convicted felon. There's no reason he couldn't possess those to begin with. Last layer of the search, or of the motion rather, is all of this evidence is then used to get the search warrant for Mr. Gathwright's house. I think everyone who testified about that agreed that search warrant would never be sought, even. It certainly would not have been approved, but for the evidence that's found in the car. I recognize, and I'm sure the state will point out, that search is being conducted by Jacksonville officers regarding really, it would appear, I don't even think it was the earlier Charles Jones shooting. It was another shooting that linked to casings that were found. But what's significant is they still seize substantial evidence that they're trying to use now in this case. And that would never have happened but for the illegalities that occurred during the traffic stop. And I believe even though it's conducted by Jacksonville and the warrant is sought in connection with a different case, it's clearly a fruit of the poisonous tree because but for the illegal stop, the illegal searches, there would never been a search of the house. And I believe those cover all of the bases that I'd be relying on for this motion.
And you mentioned, and I just want to make sure we're on the same page, you concede that the second DCA at Williams, they actually affirmed the trial court finding specifically that the law in our district at the time of Mr. Williams' arrest and Owens was the law in the second DCA at the time of Mr. Williams' arrest, and it expressly permitted the search based solely on the odor of cannabis. Thus, by following Owens, law enforcement was acting in objectively reasonable reliance on finding appellate precedent. We therefore affirm.
I certainly agree that that's what the second DCA.
Okay, and that the arrest in this case and the search of Mr. Gathwright's car occurred prior to the Williams opinion being issued, correct?
That's correct.
Okay. Okay, Ms. Wise, thank you.
And Your Honor, the state is relying on Williams v. Florida, that second DCA case as well. It is clear that there was a objective legal basis to stop that Toyota 4Runner in Jacksonville. You heard from two law enforcement officers from Jacksonville who were in separate vehicles, who both are trained and certified in estimating the speed of a vehicle. They both obtained that week-long class where they were able to demonstrate that they were able to accurately estimate vehicles within 5 miles, tested against a radar gun. They both had that training. They both passed that training. And with regards to Detective Griffin, he says that he still utilizes that training and makes that type of estimation 1 or 2 times a week as part of his duties in his present job. And they both estimated that the defendant was speeding. They chose to just give him a warning in that instance, so that there were 2 bases to believe that the defendant should be stopped. The other one was that tint, and you heard that he was actually given a citation for that based on another detective coming out there, they actually came and they measured the tint, and that was within the range that was not valid, so that he was issued a traffic citation stop based on the illegal tint that SUV had at the time. So there was a reasonable basis to do that. And you heard from Detective Griffin that he smelled the faint odor of marijuana when he was standing at that vehicle. Officer Berry had already taken the license at that point and had walked away. And based on a search of the vehicle, based on the smell or odor of marijuana, they indeed found marijuana, which again goes to support that was a credible observation by Detective Griffin, that he actually did smell the marijuana and was able to conduct a legal search of that vehicle. In searching that vehicle, any place where you could find marijuana, he found a handgun. And the defendant was 21, under the age of 21 at the time, and the defendant was arrested for 2 bases, based on possessing the marijuana and drug paraphernalia, as well as a person under the age of 21 possessing a handgun. Those were bases to arrest the defendant and conduct a inventory search of all of the vehicle. And you heard that it is protocol whenever not just a firearm, but any sort of ammunition or parts related to firearms, when they are found in a vehicle, regardless whether it's a search warrant or an inventory search, all of that gets put into NIBIN as part of their procedure. And it is the NIBIN results that lead to the search warrant, a properly executed search warrant of that house in an unrelated homicide investigation, which provides for all of the evidence then that is related in this case. It really does turn on the traffic stop, and there was a reasonable basis for law enforcement to stop that vehicle and then conduct the search that they were able to find all of the other evidence in the case. So, Judge, if there is a reasonable basis to stop, and we rely on the Williams v. Florida case, which was decided in October of 2025, where they said that no longer would you be able to use the smell to justify a search of the vehicle, but good faith reliance on binding precedent at the time, which was October of 2025, they're not going to suppress any evidence based on a search based on smell. And this search happened the year before. So we would ask that as well, Judge, that good faith reliance, that was binding precedent. That was the law at the time of law enforcement was able to conduct a vehicle search of Mr. Gathwright's Toyota SUV based on that odor and smell of marijuana. He went into his credentials, his familiarity with that smell, and that search did in fact lead to marijuana within the vehicle. So based on all of that, we'd ask you to deny the defendant's motion to suppress.
Okay, Ms. Wise, any rebuttal?
Just briefly. With respect, I recognize at least one of the detectives, I think they both talk about this, the class that they've taken. And they may be qualified at times to make traffic estimations as far as the speed someone's going. But the problem is it has to be reasonable and credible. That's what the case law says. You can estimate, but it's got to be reasonable and credible. And that's the problem. It's observing for a quarter of a mile. Can't even say what the speed limit is, even to this day. Can't remember how fast they thought Mr. Gathwright was going. So I would suggest, even though maybe they're qualified under some circumstances to make the estimate, we don't have the evidence here to support that, to show that it's reasonable and credible. Again, as to the tint violation, it's measured, but no one last week had even testified what the measurements came out to. And I believe, as I pointed out, I think they were relying on the wrong statute quite clearly when they were reasonably, in their minds, objectively determining that the tint was not lawful. Williams, again, before obviously reaching the point where Williams would come into play, there has to be a finding that the smell, that the testimony you heard was credible, that the officer actually smelled the marijuana. I don't believe that finding can be made given the testimony from last week. But even if it could be, I obviously don't agree with Williams and their conclusion that they should rely on it. But this isn't a situation, even recognizing that holding, where the officers are relying in good faith on Williams. They're trying to find any reason they can to justify the search. And they clearly, obviously, it's a pretextual search. No one's really disputing that. But it makes no sense for them to come back and rely on Williams after finding this little bit of residue. With regards to casings being placed in the NIBIN and the various other firearm evidence being collected, that's a seizure. And I don't believe that there was a lawful basis, given Mr. Gathwright is not a convicted felon, to seize casings from the car and put them in the NIBIN. That goes beyond searching for marijuana. It goes beyond even an inventory search. That is a seizure.
What's your position on whether or not there was probable cause to arrest Mr. Gathwright for the for the gun that was found in his car and he being under the age of 21?
Well, they don't do that, I don't believe. And under the circumstances, I can't agree that that would give probable cause and under arrest him for that. We don't know to arrest him for that. The car, for what it's worth, is registered in his mother's name. His mother is a retired Marine. The handgun is not in plain sight. It's deeply concealed within the car. So I don't believe there was probable cause for that. Okay. Again, even then, the NIBIN hits, the last argument I think the state was making, the NIBIN hits didn't provide a lawful basis to search the house because there would never been NIBIN hits if it weren't for all these illegalities that led to the NIBIN hits.
Okay. I understand. Thank you. Okay, I'm going to take it under advisement. I'm going to do a written order. All right. So then we have Mr. Gathwright's motion to suppress evidence illegally obtained from the defendant's iCloud accounts.
So this is a much different motion, obviously, Your Honor. It probably became apparent last week that I was a little surprised by some of Mr. Ramos' testimony. That may not have been apparent, but I set out in the motion and I was intending to argue that what I believed was a date range, a temporal limitation in the warrant was overbroad. And from Detective Ramos' deposition, in all fairness to him, he couldn't really remember every search he conducted because he conducted many searches, but it was that if there was a temporal limitation, I would have stayed within it. Clearly, he did not. He testified last week. He had no intention at any point of limiting what he was going to search from the iCloud. And he clearly did not. He searched the entire thing. That's what he testified to last week. That, Judge, I don't even know that it can be questioned. That would not violate the particularity requirement of the Fourth Amendment. This is an evolving body of law, but the cases that have addressed this, several 11th Circuit cases, and then I think the Demons case is probably the most on point state of Florida case. They recognize you going in and searching someone's iCloud account is the equivalent of a general warrant. It's just rummaging through basically their life. In this case, it was rummaging through almost 4 years of Mr. Gathwright's life. That's why a lot of this goes back to the McCall case from the 11th Circuit, but and Demons relies on that. But there have to be temporal limitations on what is being searched when a warrant is being sought for something like an iCloud account. In reading the warrant and the affidavit that Detective Ramos drafted, it could appear that there is a date range of June 1st, 24 to July 12th, 24, which I believe even that would be substantially overbroad under the current case law. But Detective Ramos stated he was not limiting the search to that date range, and he had no intention to do it. It sounds like it's somehow auto-populated that he did the affidavit. And when he submitted the request, and in the warrant that was actually signed, it basically provided free reign to review the equivalent of everything that was in the iCloud account. All emails, all instant messages, all iCloud data associated with backups, all contacts, all records and information regarding locations, all data stored in location services, all records pertaining to the type of service used, records of games, videos, other remotely accessible data, and associated IP addresses, all files, keys, basically anything you could think of that could be in an iCloud, he includes in this affidavit and in the warrant that he drafts. Even if that's problematic in itself, even if we have a temporal limitation of a month and a half, but there was no limitation whatsoever. It essentially went back to March of 2021.
Well, didn't he testify that Apple just gave him everything?
They did. And I think in the deposition, that's what he thought happened. And even if that's the case, Apple clearly did give him everything. And it's addressed in a couple of other cases I'll get into. But even if that was the case, then he would have a reason to limit it to whatever dates were in the warrant. So even if arguably this could be read in the warrant as a temporal limitation, which he apparently did not read it as, then he has a duty to confine what he searches to that. And I asked him about how, wouldn't it be easy to just click on the last access date and it organize everything by that date? You can search only things within that date range. But he had no intention of doing that. He looked at the entirety of the life of the account, almost 4 years worth of material, at least 3.5. So even if that was a limitation, and even if Apple ignored it, he made no effort whatsoever to limit what he actually searched. That, Your Honor, I think clearly violates the holdings in Blake, which I think is the probably the main 11th Circuit case that addresses this. In Blake, they addressed two different warrants. There was one to, I think it was Yahoo. There was one that they found was not problematic, although it appears in reading Blake that they were that was even a close call. But then there was a Facebook warrant in Blake that they found far exceeded the particularity requirements of the Fourth Amendment. This one is just like that. It really had no temporal limitations, and it had no categorical limitations. It was what they found to be the equivalent of a general rummaging warrant. I don't know if the state, really can even argue that did not violate the Fourth Amendment, especially the way the warrant was executed. But I think a big issue now that's addressed in the Demons case that I cite is, according to Demons, there can be an attempt to try to, I think, basically parcel out what was unlawful, what went outside the temporal limitations, and focus on what may have been reasonable. They did that in Demons, but they also said that it's not always going to be appropriate and not always going to be feasible. In that case, and unfortunately, Demons, they don't talk about why that warrant was overbroad. It appears the state agreed it was overbroad, but then they made an attempt to limit it to information from the time of a shooting that was being investigated and a few hours before and after. But in reaching that point, they noted, relying on a couple of federal cases from other circuits, one being Gulp and the other being Pilling, which I have a copy of. But they said that even when parts of a warrant may be valid and distinguishable, severance may be appropriate if the sufficiently particularized portion is only relatively insignificant part of the sweeping search, or where the warrant is generally invalid but has some tangential item that meets the requirements of probable cause. The problem here, Your Honor, is it's far from a relatively insignificant portion of the warrant, whatever might have arguably been relevant, because we have, again, 3.5 years worth of Mr. Gathwright's life that is collected in this iCloud. And really, based on Detective Ramos' testimony, there was no significant limitation that he could establish that might have been lawful. And even if there had been, he completely ignored it and went far outside of whatever limitation it might have been. I've been prepared to argue that June 1st to July 12th was substantially overbroad because it encompassed far more time than this conspiracy could have even arguably existed. And we went back and asked when was this first advertised that there would be a Charles Jones show in Tampa, and that was June 14th. So anything before June 14th could not have impacted this, could not have been evidence of the conspiracy, because there could have been no conspiracy. Nobody knew Charles Jones was going to be coming here until June 14th. The evidence or the facts set out in the affidavit are really pertained to actions that occurred June 22nd and June 28th. In any event, nothing before June 14th could have been relevant. Yet this goes 2 weeks before that and then goes substantially beyond the time the conspiracy was alleged to have existed. Under the circumstances, Your Honor, and I would I cite to most of the cases I'm relying on, but the one that I didn't cite is Pilling, which I have a copy of.
Okay.
It's referenced in Demons.
Okay.
It's a district court case from Idaho, so obviously not binding on it, but it's a very, very similar circumstance that they dealt with. And that one, and in Demons, I believe I said also relies on that, but in that one, basically it's the same thing. They get an entire Apple iCloud dump. Apparently there's some discussion about, there may have been some attempts to purge the information that would have gone outside the relevant limitations, but it states, and this is on, I believe it's the third page of the printout, that the government realized it inadvertently failed to purge the data, and essentially everything ended up being looked at. It appears that was done accidentally. Here it was done intentionally. But in any event, they go forward, find that the warrant was substantially overbroad, just as we have here. And then at the end of the case, the last 2 pages, they discuss why severance can't apply in that situation. And similar to what the court found in Demons, they're saying that you can't sever this because of the relative size of the valid and invalid portions of the warrants. And the portion that might arguably have had some relevance was relatively insignificant given the substantial size of the information that they had. Then they go on to conclude the opinion by finding additionally that the suppression was also justified because the government did not filter any of the unresponsive data before reviewing the defendant's entire iCloud account. And that's exactly what happened here. Even if in Pilling there was some attempt, there was no attempt whatsoever here. As Detective Ramos' testimony established, he had no intention of limiting anything. He was looking at everything that was going to be in that iCloud, and he did so. And I think the substantial portions of what he took out of that he finds to be relevant would have been far outside even the date range in this search warrant, but he didn't confine himself to that in any event. Good faith exception is obviously something that may be brought up. I don't see any way the good faith exception can apply here when the detective drafts a search warrant affidavit that he himself says he has no intention of limiting to any kind of temporal limitation. So even if the court arguably saw this to be a temporal limitation, it was essentially Detective Ramos deceiving the court because he said in his own words he had no intention of limiting what he was going to look at. And then even if the court did, issue what it believed to be a good faith warrant, Detective Ramos had no intention of following the limitation, and he didn't. He went far outside of it. I would suggest, Your Honor, even the date range of 6/1 to 7/12 in light of Blake and the other cases that we rely on, that's a facially deficient warrant. But regardless, Detective Ramos, number one, had no intention of the court limiting it to that date, and he had no intention of abiding by those dates. So I don't see any way the good faith exception could apply.
Okay, thank you, Mr. Weiss. Ms. Ismer, why should the state not be limited to the dates of June 1, 2024 through July 12, 2024?
Number one, because the return was accurately complied with by Apple and Detective Ramos, but also because in the months leading up to the incident, several of the items of evidence that were discovered within the time frame that's listed in the original warrant date back to or in some way connected to evidence that's also located on the device in the months before. There were several representations by the defense that Detective Ramos nor Apple abided by the warrant. I believe there was some insinuation that there was misconduct or an ill intention by Detective Ramos. But if Mr. Weiss has read the content of the search warrant, including the probable cause affidavit, what Detective Ramos requested was included in his request were the iCloud backups from both of these accounts from Mr. Gathwright's devices. And that is exactly what Apple provided. When he backed up those devices between June 1st and July 12th, the information from the months prior were included in that backup. So yes, that is what was provided to Detective Ramos. There was also the reason for requesting such information also testified to by Detective Ramos, because oftentimes those items are either mislabeled, not labeled, and now with Apple's ability to actually change the date and time on photos and videos in devices, they make requests that specifically cover that type of occurrence happening. So it's not an overbroad warrant, but more specifically, the time frame from before the offense itself has several links to the temporal timeline that was provided of June 1st to July 12th. The specific example that we gave, or at least I asked Detective Ramos about, was in particular a photograph that depicted two separate rifles or assault rifles on the ground. The photograph, as it was discovered in the device of Rashad Murphy that had been previously discussed, was sent to Rashad Murphy's device from Sean Gathwright's device within the temporal time frame that was listed in the warrant. But that photograph actually originated when you selected it or clicked on it in Mr. Gathwright's device, having been received at a time in March of 2024. And so when you actually open the file and look to created by modified date, you could see the trail of where that photograph came from, and it would certainly be relevant to this case. Neither Apple nor Detective Ramos actually violated what was requested in the search warrant or what was actually disclosed or provided in the data that he received. So in looking through the data or the backup that occurred between the temporal timeframes that were listed in the search warrant, which again is also not overly broad, but what's been stated and the evidence that they had at the time of the premeditation leading up to the offense itself, and then ultimately the flight from and attempt to conceal their identities thereafter, it's an appropriate timeline of evidence that they were seeking. Several of the Jacksonville detectives also testified about their having seen visually several of the defendants or the defendants getting into it with the victim in this case in advance of his homicide. And so having a time frame which spans before the offense itself and thereafter not only provides a full picture of all of the data that's relevant to the case, but also the relationship of that device and if there are changes. Does this device typically stay in Jacksonville? Did it travel to Tampa on this weekend? You're not only establishing direct evidence from the date of the offense itself, but also the pattern activity for that device as well.
Okay, so if I'm understanding you correctly, so the photo of these firearms that was on Mr. Gathwright's phone, it was originally received on his phone in March of 2024?
Yes, March 27th of 2024 from Isaiah Chance's cell phone.
Okay, so Isaiah Chance sends a photo of Mr. Murphy or Mr. Gathwright?
Isaiah Chance sends a photo of two firearms on the ground, rifles on the ground, to Sean Gathwright.
Okay.
That photo is then sent from Sean Gathwright's device to Rashad Murphy's device in June.
June what?
June 20th of 2024 at 3:02 a.m.
Okay, and so if I'm understanding you correctly, so in the temporal time limit of June 1, 2024 to July 12th of 2024, so the subpoena goes out to Apple and then they send in everything that was on the phone during that time period, or that account during that time period, plus any backup. So anything that was backed up during that time frame also gets produced, correct?
Yes, they would not have what's on the physical device. They would only have the backups.
Okay,
Because it wasn't a search warrant for the physical phone itself. Only whatever went to the cloud,
Right.
this, storage location. They would only have if the device was backed up, whatever that file was, and the dates of the backups. So they could
Okay.
only provide or produce backups in the timeline that they were given in the search warrant.
okay, but that then kind of becomes a dragnet that brings in, even though you're putting a temporal time limit on this application for the warrant, and that's what the judge signs, and that's what the warrant says, nonetheless, because if the device or if the iCloud accounts are backed up during this temporal time frame, then everything that was in the accounts now gets brought back in, correct?
Correct.
Okay,
The reason it becomes relevant, Your Honor, is for several points. If a file is deleted or altered in some way, it would not have a time frame linked to it. So that would come with the backup. We would often be able to see it if it's deleted and not overwritten. But if it is, sometimes you can't see the file, or sometimes you can say where it says deleted and can't open it. But those actions are also relevant if files are deleted at or near the time of the offense
Sure.
itself. Then the files that link back to the prior incidents, if they are linked to the data that's provided to the offense in some way, that photo I'm talking about from device to device between the defendants being one of the relevant examples, that is an argument as it relates to weight and relevance for the defense to make. The fact that we can trace that photo back from before this temporal time frame doesn't make it inadmissible evidence as a result of what was disclosed to us. When you open the file, if created date, modified date, and last access date, because you received the photo of guns 3 months ago, but sent them 3 days before the murder, certainly those are relevant to the case. So selecting that image, just because the data is dated before the time frame included in the warrant, it's also relevant and related directly to the time frame that we have.
right. I understand why the evidence would be relevant. I understand that argument. I guess the question I have is, if the state has the ability to acquire all of the evidence in someone's iCloud account because a backup occurred during the time frame, then it kind of makes the time frame meaningless. There is no time frame, because then if the backup occurred, now law enforcement gets everything just by virtue of the fact that the backup occurred during the time frame, and so then, which makes the temporal requirement then really irrelevant.
If the court is presented with those items that the defense seeks to exclude. So had the state presented to you photographs, which we could establish based on the electronic data that dates had been changed on to before the offense, or that had been deleted, the court would have to look to those items to determine whether they were within this time frame, whether there was something in those photographs which allowed us to date it, or there was some evidence of them having been modified, which is why we would not exclude all of the evidence, but instead the defense would have to at least specify which items they are indicating are outside of that.
Okay, are you prepared to do that, Mr. Wise? Are you prepared to make the argument that specific items of evidence are outside of the time frame on the subpoena and therefore shouldn't come in?
I certainly would have been, Your Honor. One of the things I asked to take from was him with his demo. He claimed there are photos where Mr. Gathwright is making what he believes are gangs. In my review, I don't think any such photos would have been within this time frame. So I asked him again last week, which ones are you talking about? Because I'd like to try to identify. This has almost 14,000 photographs. So it's not something I can do easily, but I've parceled out the ones I think might have a gang sign. None of them are in that data. So the short answer is yes, Your Honor. Again, I don't think this is severable. I think the entire thing should be suppressed, but even
I understand.
even if it's limited, yes. I mean, I'm gonna ask the state to establish a basis for every piece of evidence from that iCloud to show that it came from whatever the court finds to be the appropriate date frame.
Yeah, okay.
I can add my phone, but
Yeah, no, I hear you. And I'm probably asking the wrong person. So shouldn't it be your responsibility to identify what items of evidence, assuming I find the time frame of June 1 through July 12th to be appropriate? Just assume for the sake of argument I do. wouldn't it be your responsibility then to identify what items of evidence the state would intend to admit at trial? And then I would hear argument on whether or not that would be admissible. Would that be your job to do?
Well, at this time, Your Honor, the state's position is that the items that have been received in the response are admissible items. If the court is limiting the state's date range, then the state would obviously assert that the dates that are provided in the warrant are more than satisfactory based on the probable cause that's stated in the warrant. The issue then becomes the images that can be connected to or dated back to the other evidence in the case. So there are ways that the state can articulately provide those items, meaning we just have an evidence view of those items sooner rather than later. And certainly we can do that as it relates to the iCloud account for Mr. Gathwright, if that would be beneficial to Mr. Wise, but nothing about that type of evidence view would change the state's position specifically as it relates to the timeframe that's listed.
Okay. All right. Mr. Wise, any rebuttal?
Yes. I think one, I certainly disagree that Detective Ramos and Apple did not violate this warrant. I think Detective Ramos' testimony last week, he more or less admitted. I mean, he did admit. He said this basically auto-populated, and even if that was, which I think it's reasonable to read that as a date limitation, and I think Judge Smith likely did,
Right.
but Detective Ramos sure didn't, because he said himself he went far outside that. And with respect to the backups, if an account is backed up, it may be relevant to see evidence that it was backed up during that range, but that doesn't just open the door to look at everything that was on backup. Because if we're doing that, I mean, what's the point of putting any limitations in this warrant?
That's my question.
Right. So I don't see how, again, the fact that it's backed up, sure, that's relevant. If you find that the warrant's severable, but that doesn't open the door to just look at everything in there, and that's what happened. And looking at the hard drive that I have, it doesn't distinguish that I can tell, and I'm far from a tech expert, what was the backup and what was not. It gives two accounts, which are the two that are in the warrant, and I don't see how it distinguishes between what was backed up and what wasn't. It's just everything. And that includes almost 14,000 photos, 400 and something live photos. I can't remember how many videos. I believe a few hundred, if I recall. It's his life for 3.5 years.
Yeah,
I'm
no, I
not
hear you.
exaggerating. One thing I would add, and I recognize if the court finds some temporal range to be appropriate, I agree that if there's a photo maybe that's older that is sent during that range, that may be lawful under the warrant. But the problem is, and it's very easy, by the way, to do that, as Detective Ramos testified. You've got categories. You can click last access, date created, last modified. You can sort them all that way. It takes a long time because of the data for it to populate, but it's as simple as clicking a button. So it's pretty easy, I believe, to determine what would have been at least accessed during that range. But that doesn't open the door to going down trails that take it far outside. I mean, if a photo is from 2021 and it's sent during, June 24th of 2024, and the court finds that appropriate, I agree that would be within the range, but you can't keep going down rabbit holes and going far outside the range. And I think that's the problem. One thing I would point out, because I know it was brought up that, there may have been something that Jacksonville detectives knew. Obviously, the search warrant affidavit is confined to what's in the four corners of the affidavit. So I don't believe that, if there's other evidence Jacksonville knows would give reason to go outside the warrant if that's not something that's included in the affidavit. I've given my reasons why I don't believe this is severable at all. But I think even if it is found to be severable, this date range, and this is what I was prepared to argue before last week, is overbroad as it is. Again, anything before June 14th, I think, could not be relevant. This has a 1.5-month range, far beyond what they found in Demons to be appropriate, which was just a few hours before and after shooting. So in no way am I conceding that this warrant is severable at all. But even if it is, the date range we have is substantially overbroad, and I believe it would be a violation of Blake in the many cases that it addresses.
Okay. Interesting. All right. I'm going to take this one under advisement as well. But State, if I were you, I would start looking at the items of evidence that you would specifically intend to introduce. And if it was outside of the date range that was in the warrant application, which would be June 1 through July 12th of 2024, and the only reason law enforcement gets a hold of it is because the account was backed up. That's the only way they get it. You all need to start looking at what items of evidence you would actually intend to introduce, and you need to have an argument as to why. Okay? If I were you, I'd start doing that. Okay? All right. Very good. I think that's it on the motions to suppress, correct?